Well, one of the country's most selective boarding schools under the microscope today as the trial of one of its alums begins. Jury selection is happening now in the trial of Owen Labrie, the 19-year-old accused of raping a 15-year-old girl days before graduating from St. Paul's School in New Hampshire. Labrie pleaded not guilty, telling police he never had sex with the victim, but he did go into great detail apparently about what's described as a school tradition called the senior salute, where he says older classmates try to hook up with younger girls. Joining us now, criminal defense attorney Whitney Boan and former prosecutor Jonna Spilbor, who also has served as a criminal defense attorney as well. And that's really where we're going to focus today, on his arguments. Jonna, I'm curious what you think about this case overall. This is the elite of the elite, $54,000 a year to go to this school. Right. Secretary Kerry, FBI Director Bob Mueller, 13 U.S. ambassadors, multiple Pulitzer Prize winners have attended this elite school. Just so our viewers know, when we say elite of the elite, that's what we're talking about here. Right. How does that impact the case?
I don't think the fact that they have a very elite alum is going to impact the case so much as this actual revelation of the the senior salute that is coming forward in this case. And I'm actually, it's confusing and distracting, because here you have an alum who's saying, no, I did not commit rape. In fact, I did not have sex with this person. But at the same time, he goes into this illustrious recitation of this disgusting and horrible program, for lack of a better word, that's going on this campus, and apparently has been for a long time. So the school is not on trial right now. Only this defendant is. So how this is going to play into whether or not a jury finds him guilty or not guilty is a mystery.
Interesting. Whitney, the lawyer that is currently defending this young man also defended Whitey Bulger, the former mobster who's now sent to prison for life. If you were the lawyer, and he has not commented yet about whether or not his client is going to use this as part of his defense, would you use it? How would you use this tale about the school? We don't know if it's real or not. How would you bring that into the case?
Well, I don't know if I would or I wouldn't. I don't know that he can necessarily avoid it, however, because his client went ahead and talked about it when he gave a statement previously, which as a criminal defense attorney, ideally, I would prefer my client not give a statement, especially based on some of the things that this individual said, because they're not the most likable things that he could have said in terms of he stopped and didn't have sex with her because he had some divine inspiration.
That's what he actually said. Right.
Yes, yes, and him saying, you know, that a younger class woman would say something like this because it would be a point of pride to sleep with an upperclassman. You know, it's not likable, but let's keep in mind here, he's not on trial for being likable. And I agree with Jonna, he's not on trial, or excuse me, the school is not on trial here. Who's on trial is him, and the issue is that they don't have any physical evidence. And it sounds like this is rather a kind of attenuated sort of reporting as far as how this even came out in the first place, that it came from a counselor, that came from her mother, that came from her, which I will say doesn't mean it's not true. It just means the prosecution may have a harder time proving this case with a lack of physical evidence and a kind of hearsay within hearsay in terms of the reporting sometime after the incident. Well, if it did happen, they couldn't maintain any physical evidence at that point.
Jonna,
and they're going to have a harder time proving their case.
The victim did go to the hospital. The hospital said her injuries were consistent with rape, but to Whitney's point, there is a little bit of a question of is it just a he said, she said case at this point? I can't help but think about the Rolling Stone magazine. In fairness, the Rolling Stone story really focused it on this group that was very unlikable, which was the fraternity system at the school. And basically indicted the entire system. And I wonder how that plays in here. The same sort of feeling. This, you know, the boarding schools don't necessarily get the best reputations, and I just kind of wonder how that could be, you know, again, going back to in fairness, how that's part of this story even getting the press.
Well, oftentimes in rape cases, it turns into a he said, she said, because for whatever reason, somebody doesn't get the DNA evidence, they don't go to the hospital, they don't report it, etc. What the victim in this case is going to have on her side is this is not college, where sometimes, you know, people have the morning after regret. This is a boarding school where these are teenagers incapable of consenting to sex until in New Hampshire the age of 16, which in my opinion is awfully young, but that's the state of the law in New Hampshire. So the jurors are going to be looking at this victim as, you know, not a consenting adult in any way, shape, or form, but as a child. And when you factor in this convoluted story of this sexual tenor at this school, the jury just might come back even with the lack of physical evidence and find that there is enough to convict this kid.
And it'll be interesting to see who takes the witness stand then, Whitney, because you even have alumna writing to the Boston Globe saying this sounds consistent to what we saw in school while we were in school there. The question is, you bring back all this alumni to testify against this one guy, and if that would even be allowed. Let me ask you this final question, though.
I don't think it would be allowed.
Let me about this specifically about Owen Labrie, though, the man on trial. He also served as a prefect for the hall, and so he went through special training. You know, what is statutory rape? It went through all of this, and I'm curious about how that also is applied here, because he, more than anyone, would know better.
Right, and I mean, I just don't know that the issue here becomes about as much the school as it is in the story and how it's been played out in the media. I mean, we're talking about someone who's on trial for acts that he's accused of committing, and the state or the prosecution is going to have to prove that beyond a reasonable doubt with actual evidence, not just conjecture, not stories about what the culture is at that that lower elementary, I guess, secondary boarding school. It's going to have to be actual evidence. So the fact that, you know, you're saying that there are all these witnesses who are willing to say this is consistent with what went on there, you know, that is indicative of a larger problem. But that does not make him guilty of a crime.
That's interesting. It's a good point to end on right now. It's something we're going to be watching. Again, jury selection begins, so the case is just in the first stages. Whitney and Jonna, great to have you both. Thank you.
Thank you.
Thank you.